Thank you, Mr. Speaker, for allowing me to make this statement. The AGC made a reference to the Court of Appeal on the City Harvest case, or City Harvest Church case. Two questions were asked on the 1st of February 2018, last week. The Court of Appeal released its decision on the reference. I want to set out the government's position now that the Court of Appeal has said what the law is. The key question related to the liability of company directors, governing board members, key officers of charities, officers of societies. When they commit criminal breach of trust or property which belongs to the organization, what happens? The Court of Appeal ruled that such officers are liable to be punished under Section 406 of the Penal Code. That provides for a maximum sentence of 7 years imprisonment or fine or both. The Court of Appeal also ruled that these officers do not come within the term or meaning of professional agent, and that therefore they were not liable for the more serious penalties under Section 409 of the Penal Code for CBT. Section 409 provides for a maximum of life imprisonment. The government's policy is clear. If you are a senior officer, director in the organization, you are in a position of greater trust. You have considerable authority to make decisions in relation to the organization's assets. If you abuse that trust, you should be more culpable, and you should be liable for more severe punishments compared with an ordinary employee. That's really common sense, and there can be no question about that. For the last 40 years, the law, as applied by the courts, reflected this principle. In 1976, the High Court ruled so in the case of Te Chua. It said that directors are liable for the aggravated offense provided under Section 409. After that decision, the position was clear, settled law. The law was applied in that way for over 40 years by courts in other cases. There are at least 16 decisions reported applying this principle, and there must be many other unreported decisions. In April last year, however, the position changed. The High Court ruled that directors cannot be liable under Section 409. That was contrary to the decision in 1976 and the way the courts have applied Section 409 over these 40 years. The government asked AGC what should be done, what further steps ought to be taken after the High Court's ruling. AGC advised that a clarification should be sought from the Court of Appeal by way of a reference. We now had two conflicting positions from the High Court. One, Te Chua in the line of cases that applied Te Chua, and second, the City Harvest Church case where the court disagreed with Te Chua. The Court of Appeal gave its decision, as I said earlier, last Thursday, in response to the two questions of law submitted by the Attorney General's chambers. The Court of Appeal's decision means that there is now a lacuna in the law. As it stands today, ordinary employees can be charged under Section 408 of the Penal Code. That provides for more serious penalties for criminal breach of trust compared with Section 406. It is punishable, 408, it's punishable by mandatory imprisonment up to 15 years and an optional fine. Directors, however, can only be charged under Section 406, which provides for a lesser punishment up to 7 years jail or fine or both. The Court of Appeal itself acknowledged this gap in the law, and it said there was no good policy reason to ignore the heightened culpability. I quote, no good policy reason to ignore the heightened culpability of directors and key officers of charities, societies, companies who commit criminal breach of trust. The Court of Appeal also pointed out that the obligation of the court is to set out the legal position correctly, what the law says, and leave it to Parliament to amend the law as it deems fit. It is now up to Parliament to amend the law, and that we should do soon. We will ensure that legislation provides for higher penalties for directors and other senior officers who commit criminal breaches of trust. We hope to make the amendment together with the other wide-ranging amendments to the Penal Code, which I've spoken about them. To the House, let me make one final comment. We are aware that many have expressed their dissatisfaction with the outcome. Expressing one's unhappiness with court decisions is fine, but it should not sink to the level of abuse, insult, and contempt. We have seen comments online that the judges let off those who are rich, that some judges were lenient because they were Christians, and so on. That is not right. Judges should not be personally attacked, their integrity impugned, just because people do not agree with their decision. There may be unhappiness. People are entitled to disagree with the decision, but let's not attack the judges. The government believes that the sentences are too low, but the sentences reflect the law as it stands after the High Court's decision last year, confirmed by the Court of Appeal. The courts decide these matters. All of us have to respect the decision, regardless of whether we agree or disagree with it. Thank you, Mr. Speaker.
Second tempo.
For the clarifications. I think as rightly pointed out, I also personally received a lot of feedbacks. On the ground, people are commenting that the court let go those are breached lightly, and also those that actually can cut off for religious reasons. And worse, they also comment that for this particular case, it was handled by a so-called lawyer who was also an MP from PAP. So may I know what is the minister's stand on this and clarification on this and on these comments, and also what the government can do about all these comments, and also how should we proceed from here? Thanks.
I thank the member for the question. I think Mr. Edwin Tong would not be entirely happy to be called a so-called lawyer and MP. I said I think he is a qualified lawyer in the senior counsel. I said earlier that it's entirely legitimate to express one's unhappiness about court decisions. But some statements have indeed gone too far, abusing the judges personally, ascribing improper ulterior motives to their decision. And it's a clear case of abusing the anonymity of the net, or anonymity to the extent that it exists. Just because you don't agree with the judges doesn't mean that you have the right to abuse them and challenge their integrity. People who abuse judges, challenge their integrity, will be prosecuted if a case for contempt can be made out. I will set out later some factors which would be relevant in this context. The courts should not be pressured by public opinion. They should be free to decide in accordance with what they believe the law to be. Criminal cases must be tried in a court of law, not in the court of public opinion. A few years ago, I had already expected that there would be more and more of such scurrilous attacks on the judiciary. If left alone, they will become the norm. That is why we legislated into law the Administration of Justice Act. One of those opposing it, I think it was Mr. Pereira, asked me in this House, why the need for this law? This is one relatively small illustration. If we do nothing, it will get much worse and become unsolvable. We don't want to end up like the United Kingdom, where the press freely attacks the judiciary. You get newspaper headlines, screaming banner headlines, labeling judges as enemies of the people, you fools, because the courts had the temerity to decide in a way that the media did not like. If we are not careful, we will easily go down that route. Let me give members a current example. There is a public Facebook group with a Chinese name, which I understand can be translated as a policy discussion forum. I was informed that a copy of a news article was posted on the 2nd of February last week on this Facebook. The article had appeared in the Chinese news daily Wanpao on the same day. It was a report on the CHC matter. The title of the news article is a banner headlines had, however, been faked in the Facebook post. The original title translated was, and I quote, "Outdated law saved the accused from harsher penalties." Someone appears to have faked the title into, and I quote, "PAP lawyer saved the accused from harsher penalties," making it look as if a mass circulation newspaper had done so, probably to give more credence to the headline. AGC takes a view that the suggestion from the fake title is that the PAP MP was responsible for an unfair, unjust outcome, and the courts have let off the defendants lightly because of him. AGC's view is that this is a case of contempt by scandalizing the courts. I don't want to go into the meanings of the fake title because the matter is with AGC, and it will be dealt with in accordance with the law. Whatever the meaning of the statement, and regardless of whether or not it is in contempt, one can see that this sort of attack based on deliberate faking is quite unacceptable. I cannot see how any reasonable person will justify such faking as a legitimate expression of free speech. I have asked the police to take a serious view of those who scandalize the court, not only for this case. If there are other comments which cross the threshold and are in contempt of the court, our approach is that action will be taken. That has been so before the AOJP, and it remains so after the AOJP. In coming to a decision whether to prosecute for scandalizing the courts, the factors will include assessing who said it, how seriously is the statement likely to be taken, how wide was the publication, other relevant factors. That's always been the case, even before the AOJP. AGC will assess the various statements that have come to their notice in this context. And quite apart from whether the fake headlines scandalize the court, there is another point. Defendants are entitled to get a lawyer of their choice. Rule of law, a civilized system of having trials in court, depend, amongst other things, on lawyers being able to act for defendants, whatever offenses the defendants are accused of. As I've said before several times, even a child rapist is entitled to his day in court and to be defended. It doesn't mean that we or the lawyer defending the person approves of child rape. But the defendant has the right to choose a lawyer to defend him, and we must not take that away from him. Lawyers should not be made to feel that they'll be hounded online if they take up cases. Let me share a personal example with members. From practice, when I was in practice, I am probably in the unique position in Singapore of someone who has both acted for the 3 prime ministers of Singapore and also of having acted against all 3 of them. In 1995, PM Goh, SM Lee, and DPM Lee, as they were then, sued the International Herald Tribune for libel. The IHT came to me. The conversation as to whether I will act for them took about 2 minutes. I told them they must know I was a PAP MP. Were they comfortable that they will get the best possible advice from me, given my position? They knew that I was an MP, PAP MP. They said it was okay with them if it was okay with me. It was okay with me. I didn't see any need to clear with the party or anyone connected to the party or government. By taking on the case, I was simply doing my professional duty. I didn't need to take on the brief. I was very busy with other work, but I thought the IHT had a right to counsel of its choice. They were faced, obviously, with particularly formidable plaintiffs who could get counsel of their choice, and so I should help the IHT. The import of my acting for the IHT, and it went to court, did not escape Senior Minister Lee Kuan Yew. In court, after his evidence was over, and before he stepped out of the witness box, he said he had to point out the situation. He said that I was close to the three of them, meaning the Prime Minister, Senior Minister, and Deputy Prime Minister. I was a PAP MP. The decision by the IHT, despite this situation, to instruct me was, and I quote, the highest tribute to the integrity of the Council and, quote, possibly reflected also on the integrity of the government. Over the years, I have also acted for various others whose conduct will not be approved of by the general public, and some of whom were impecunious and could not pay fees. I acted for them whenever I could, based on certain principles, which I do not need to go into here. The fake headline that I referred to earlier in the Facebook page is part of a mob mentality to hound lawyers, to intimidate them into not acting in cases which the mob disapproves of. It's quite shameful. Supposing no action is taken, when public Facebook pages do this, then what is there to prevent the media itself from publishing such articles in the future? Supposing by action here, I don't necessarily just mean contempt action. If we accept such faking as normal, then you can see that the line between that and the current position in the UK almost disappears. You will then get in the mainstream media the headlines I earlier spoke about judges abusing them, other similar sorts of things. We should not get there, and it will be a sad day for Singapore if we do get there. Thank you, sir.
Ms. Cheng Liwi.
Minister, the Court of Appeal noted that a review of the law is long overdue. Why didn't the government amend the law earlier?
I said earlier that in the case of, since 1976, the position has been settled, clear law, from the time the Teochew War case was decided. I think I mentioned there are at least 16 reported decisions in the books confirming that decision over the years. There must be many others which are unreported. So the position has been consistently applied by the courts for 40 years. No doubts or uncertainty were expressed by our courts. Prosecution, defense, everyone proceeded on that basis. And there was no suggestion that the law was in need of any review. There was therefore no reason for Parliament to review the position or amend the law. No, Parliament does not legislate in vain. Thank you.
Mr. Yee Chia Sing.
I'd like to thank the Minister for the ministerial statement, and I'm very happy to note that the law is under review. One key fact of this whole City Harvest thing is a key beneficiary, which is the wife of Ms. Kong Hee, was not charged for any offence. In reviewing the law, will the ministry also look at whether to put in some penalties where the beneficiary of a CBD case can also be charged under the law? Thank you.
I think one has got to be careful about this. A beneficiary who receives proceeds without, the appropriate knowledge does not automatically become a criminal. Supposing the person took the money and donated it to a charity, another charity, does the recipient commit a criminal offense? I think we need to be careful. The law as drafted, it's wide enough to deal with people who act with criminal intention, conduct, misuse property. There is a lacuna in that Section 409 does not apply to directors, senior officers, in the way the Court of Appeal has construed it, and we should fix that lacuna. But knowing receipt of property to the extent that it needs to be criminalized, you will find it in the law. Thank you.
Mr. Vikram Nair.
I thank the Minister for the clarifications. Will this case have a big impact on future cases, especially between now and the time the law is changed? Thank you.
For the cases involving directors or similar sorts of senior officers, where the cases are already before the courts, obviously you will now have to apply the law as determined by the Court of Appeal. For the cases which are being investigated, where AGC is considering the charges, again, obviously, one has got to, the AGC will have to take into account the decision by the Court of Appeal. And if there are any charges to be brought in respect of actions that have taken place before any legislative changes, I'm sure AGC will take into account what the appropriate charge is. It doesn't automatically mean that any changes will not apply. I don't want to go into those things. But I think we identify a lacuna. I mean, it has been identified for us, and we need to deal with it. Thank you.
Mr. Gantiampo.
I have additional clarifications. I also hear comments, seeing that it has been practiced for so long, it has been consistently practiced, why the court suddenly changed, seeing that this is precedent, it should follow the precedent, and change should be thereafter.
Order. Can I just remind members that we are not here to question the specific decisions in the court?
I will send a copy of the judgment to Mr. Gan online because it's 150 pages or more. And the judges explain their thinking. I mean, in summary, they feel that when the law was drafted, Section 409 was drafted, it was some time ago, and it could not have been the intention of the drafters to deal with directors, because company law hadn't developed to the extent that it has now. And therefore, it could not have been within the minds and the drafting intention. And therefore, it should be, you need new provisions which deal with it. There are different approaches to interpretation. The other approach is to say, well, you take those words and you apply it as circumstances evolve. They also explain why they didn't want to do that here. I mean, that, in 2 lines, I'm probably not doing full justice, but that's the sense of it.
Order. End of ministerial statement. If I may just remind members to read your standing orders with regards to, I think, comments on reflecting on especially on standing orders 21(1)H and 59 in future and any discussions relating to issues like this. End of ministerial statement.